When the Supreme Court overturned Roe v. Wade, it did more than just allow states to ban abortion. It showed how this court views rights not explicitly listed in the Constitution.
Welcome to WatchMojo, and today we're counting down our picks for the top 10 most controversial Supreme Court decisions.
Despite growing dangers from climate change, tonight the U.S. Supreme Court curbing the government's power to fight it. In a 6-3 decision, the court's conservative majority limiting the Environmental Protection Agency in how it regulates power plant emissions under the Clean Air Act.
For this list, we're looking at U.S. Supreme Court rulings that were intensely debated and divisive in their day. Do you object to these rulings? Give us your argument in the comments. Number 10. Marbury v. Madison.
Sometimes our best opportunities come wrapped in our worst problems, Mr. Washington.
This case about an undelivered notice ended up having momentous consequences. Before leaving office, President John Adams appointed like-minded Federalists to judicial positions to hamper incoming President Thomas Jefferson. So, Jefferson told his Secretary of State, James Madison, not to deliver the remaining commissions. After one William Marbury filed a lawsuit demanding his notice, Chief Justice John Marshall took the opportunity to argue that Congress had been wrong to give the Supreme Court jurisdiction over such cases, as it wasn't outlined in the Constitution.
It's always been my belief that the only way to safeguard the Constitution was to put it in the hands of the judiciary. Not in the hands of the legislative, not of the executive.
In doing so, he established not only that the Constitution is actual law, but also the principle of judicial review, allowing courts to strike down laws deemed unconstitutional. The validity of how Marshall got there is debated by legal scholars to this day. Number 9. Citizens United v. Federal Election Commission. Depending on who you ask, this ruling was a win for free speech or for wealthy special interest groups.
If you believe that, we ought to go back to monarchy, that the people are such sheep that they just swallow whatever they see on television or read in the newspapers.
The plaintiff was conservative nonprofit organization Citizens United, who wanted to air a film critical of Hillary Clinton right before the 2008 Democratic primary elections. The Supreme Court's ruling struck down restrictions on corporate spending for political campaigns. The decision was split 5-4, with dissenting Justice John Paul Stevens arguing that it flew against a common-sense need to, quote, prevent corporations from undermining self-government. Republican Senator Mitch McConnell praised the decision as restoring First Amendment rights, while President Barack Obama asserted that it, quote, opened the floodgates for an unlimited amount of special interest money into our democracy.
There's nobody who operates in politics that has perfectly clean hands on this issue. But what is also true is that all of us should bind ourselves to some rules that say the people who vote for us should be more important.
Number 8. Lochner v. New York.
And then the oven here would belch lots of hot fumes, also laden with coal dust, and the bakery workers were breathing this all day.
This ruling was for workers' own good. Or at least that was the supposed idea behind the Supreme Court's decision that states couldn't set maximum work hours for businesses. In 1899, bakery owner Joseph Lochner was charged for breaking a New York law that limited work hours for bakers to 10 hours a day or 60 hours a week.
Lochner argued that the act interfered with the freedom to contract for a person's labor, protected by the Due Process Clause of the 14th Amendment.
In a 5-4 ruling, the Supreme Court decreed that this law interfered with, quote, the right and liberty of the individual to contract.
Justice Holmes wrote a now famous dissent to say that the majority's holding went too far in imposing a particular economic theory on the Constitution.
For the next few decades, during what is now known as the Lochner era, the Supreme Court invalidated numerous statutes that regulated working conditions. This included another controversial case in 1918, Hammer v. Dagenhart, in which the court struck down a federal law regulating child labor. Number 7. The District of Columbia v. Heller.
Hoping to reduce violent crime in the city, the Washington, D.C. City Council passed the Firearms Control Regulations Act of 1975, which effectively banned individual gun ownership in the district.
About 2/3 of Americans support stricter gun control laws. However, it remains an extremely heated issue, with much debate centering on how to interpret the Second Amendment. Does it grant the right to bear arms to private individuals or just state militias? In 2008, the Supreme Court affirmed 5-4 that individuals have a right to own guns, striking down a handgun ban and safety rules in the District of Columbia. This was followed up by a ruling in 2010 that the right is enforceable against the states, and in 2022 that the possession of pistols in public is a constitutional right.
Within minutes of that Supreme Court decision striking down New York's concealed carry law, New York City's Mayor Eric Adams immediately condemned it.
This decision has made every single one of us less safe from gun violence.
Needless to say, these decisions have been fiercely debated by advocates for and against gun control. Number 6, Miranda v. Arizona.
Look, it obviously starts with you have the right to remain silent. I know you've heard this before. And then I think it sounds something like, well, the thing, you have the right to remain an attorney.
Thanks to police procedurals and legal dramas, pretty much everyone is familiar with the Miranda warning. However, it was seen as quite radical when it was established in 1966. It's named after Ernesto Miranda, who was convicted of kidnapping and rape based on a confession during interrogation. Miranda's lawyer argued that this confession wasn't voluntary, as Miranda had not been informed of his rights. The Supreme Court ruled in his favor, based on the Fifth Amendment's self-incrimination clause.
The risk of psychological intimidation was plain in several of the consolidated cases here. For example, Miranda suffered from mental illness, and Stewart had dropped out of school in the 6th grade.
The larger idea was to address coercive interrogation tactics. However, in 2022's Vega v. Tico, the court ruled 6-3 that police can't be sued for failing to administer the Miranda warning, contending that the warning is a requirement for evidence in trials, not a substantive constitutional right. Number 5, Bush v. Gore.
Vote-o-matic machines and conflicting rules about ballots and fuzzy rules about what is a vote.
It's slightly detached.
The 2000 United States presidential election was neck and neck, and it all came down to Florida. Republican candidate George W. Bush inched ahead of Democratic nominee Al Gore, but by so few votes it triggered a machine recount. This reduced Bush's margin of victory. According to a media review, Republican officials in 16 counties didn't actually do any recounts, but Gore demanded manual recounts in just 4 counties. Ultimately, the Supreme Court decided 5-4 to halt the recount, arguing that different counties had different counting standards, and that a uniform standard couldn't be established before a safe harbor deadline.
The court declared that the recounts violated the 14th Amendment's Equal Protection Clause because there was no uniform standard for counting all ballots.
Justice Antonin Scalia claimed the recount posed, quote, irreparable harm to Bush. Would Gore have won? Probably not with those 4 counties. With a statewide recount of rejected ballots using a uniform standard, that's another story. Number 4, Obergefell v. Hodges. Same-sex couples have fought an uphill battle for equal rights. In 1986, the Supreme Court upheld the constitutionality of a law against sodomy in Georgia. A decade later, Congress's Defense of Marriage Act denied federal recognition to same-sex marriages. It wasn't until 2003 that the Supreme Court overturned its ruling on sodomy laws.
There are some things the state cannot do to direct the moral content of your life, and controlling your sexuality is one of those things.
In the 2013 case United States v. Windsor, it also struck down Section 3 of the Defense of Marriage Act. This ruling paved the way for the landmark decision in Obergefell v. Hodges, which actually consolidated 6 lower court cases, requiring all states to recognize same-sex marriages.
I know in my heart that John is with me today. That man cared for and loved me for 21 years, through thick and thin. Today's ruling from the Supreme Court affirms what millions across this country already know to be true in our hearts. Our love is equal.
The news was celebrated by many as conferring equal rights, but condemned in conservative religious camps who argued that it curtailed religious liberty.
Texas Senator Ted Cruz called it illegitimate and lawless. He would like a constitutional amendment that would abolish the lifetime appointment of Supreme Court justices and allow voters to have a chance to remove them from the bench.
Number 3, Brown v. the Board of Education of Topeka. During the Reconstruction era, Congress abolished slavery and passed acts to protect the rights of African Americans, including access to public accommodation and transportation. However, in the 1883 civil rights cases, the Supreme Court stepped in, ruling that Congress cannot outlaw racial discrimination by private individuals. In the 1896 case Plessy v. Ferguson, the court decided that segregation was constitutional, provided facilities were equal.
Plessy v. Ferguson determined that Black Americans could be kept separate from white Americans in public spaces and facilities under the premise, the false premise, that those facilities were actually equal.
This separate but equal doctrine ushered in a period of racial segregation that relegated Black people to second-class citizens. Only in 1954, with their unanimous decision in Brown v. the Board of Education of Topeka, did the Supreme Court overturn this, ruling against segregation in public schools. It was a victory for the civil rights movement, but was met with passionate resistance from many white residents of the Deep South.
After Brown v. Board overturned separate but equal in schools, riots and violence erupted all over the country. White protesters terrorized Black communities throughout the South, especially in South Carolina, Georgia, and Mississippi.
Number 2, Roe v. Wade. There are few issues as divisive in the U.S. as abortion. For half a century, however, the Supreme Court ruling on Roe v. Wade held sway. Plaintiff Jane Roe, a pseudonym, had filed a lawsuit against District Attorney Henry Wade, arguing that Texas's laws against abortion were unconstitutional. The Supreme Court ruled 7-2 that the right to privacy includes a right to abortion. Regulation was permitted to protect a pregnant person's health from the second trimester on, and prenatal life in the third. This incensed anti-abortion activists, who equated abortion with murder. In 1992, the trimester framework was replaced with fetal viability at 24 weeks. Just as controversial as the original ruling was the 6-3 decision to overturn it in 2022, which pro-abortion advocates saw as violating reproductive rights.
While 16 states and the District of Columbia have laws that protect the right to an abortion, 22 states have laws that could ban all or most abortions now that Roe has been reversed.
Before we unveil our top pick, here are some honorable or dishonorable mentions. Exxon Shipping Co. v. Baker. The court reduced punitive damages for victims of the Exxon Valdez oil spill from $2.5 billion to $500 million. Snyder v. Phelps. This ruling allowed the Westboro Baptist Church to continue protesting at funerals. Engel v. Vitale. Justices ruled that official prayers in public schools violated the separation of church and state. Loving v. Virginia. The court unanimously struck down laws banning interracial marriage. The National Federation of Independent Business v. Sebelius. The court upheld Congress's power to enact provisions of Obamacare.
Before we continue, be sure to subscribe to our channel and ring the bell to get notified about our latest videos. You have the option to be notified for occasional videos or all of them. If you're on your phone, make sure you go into your settings and switch on notifications.
Number 1, Dred Scott v. Sanford. The Supreme Court's ruling in this case has been described as its worst decision of all time. Plaintiff Dred Scott was an enslaved Black man who argued that because his owner, John Sanford, had brought him in and out of territory where slavery was illegal, he had been freed. The court ruled 7-2 against Scott, declaring that the Constitution doesn't include citizenship for people of African descent.
Chief Justice Roger Taney wrote in the majority opinion that Scott did not have the standing to sue because enslaved African Americans weren't citizens of the United States.
Chief Justice Roger Taney went further, striking down a federal law known as the Missouri Compromise.
In exchange for Missouri's admission as a slave state, the Northern Territory of Maine would be admitted as a free state. This ensured equal representation between the North and the South. A second part of the compromise banned slavery throughout the remaining Louisiana Purchase territory north of latitude line 3630.
To describe this decision as controversial is putting it mildly. It pleased slaveholding states, but the others were furious. And 4 years later, the American Civil War engulfed the nation. Did you enjoy this video? Check out these other clips from WatchMojo, and be sure to subscribe and ring the bell to be notified about our latest videos.